It appears the Department of Justice has had enough of Trump-appointed federal Judge Aileen Cannon. They're now asking an appeals court to step in and fast-track the whole special master review process of those documents seized at Mar-a-Lago, basically saying it's time to take much of this out of Judge Cannon's hands. It comes after Cannon last week overruled the special master who Trump chose and who she appointed. In a surprisingly favorable ruling to Donald Trump, Cannon telling Trump's team they do not have to present any evidence or formal claim to identify whether the FBI planted evidence, as Special Master Judge Raymond Dearie had ordered, and as Trump himself has so widely suggested. The judge has also pushed back the timeline for when the Special Master's work must be completed. The 11th Circuit Court of Appeals, with a panel of majority Trump-appointed judges, already overturned Judge Cannon's ruling, preventing the government from reviewing classified documents found at Mar-a-Lago. They almost blasted her legal arguments, mocking her almost in the process. And so the government, obviously seeing an opening, now asking the same court to step in with regard to the other 11,000 records, totaling 200,000 pages. Quote, the government is thus unable to examine records that were commingled with materials bearing classification markings, including records that may shed light on, for example, how the material bearing classification markings were transferred to plaintiff's residence, how they were stored, and who may have accessed them. And they said, absent such resolution by this court, the special master proceedings could result in prolonged litigation, including through repeated appeals to the district court from reports and recommendations and other rulings issued by the special master. They're basically saying, unless the appellate court gets involved, it's now clear this could go on forever. Now, in response to the DOJ's filings, previously benched Trump attorney Chris Kise has reappeared to argue the Trump team should get more time, not less. And in a footnote, Kise added, President Trump disagrees with and objects to the government's distorted and argumentative presentation of facts concerning the unprecedented raid of his home, its conduct in these proceedings, and the procedural history of this case. Meanwhile, there's some breaking news tonight from the Washington Post that reports that earlier this year, Trump allegedly asked another one of his attorneys, Alex Cannon, to tell the National Archives that Trump had returned all documents the agency requested. Cannon reportedly declined, saying he just wasn't sure that was true. But big picture, what happens now? Is the appeals court going to step in and basically tell Judge Cannon how to proceed from here on in? Joining us again is Michael J. Moore, former U.S. Attorney for the Middle District of Georgia. He's been very measured in his analysis of the Trump investigations, neither jumping up and down like those on the left or minimizing the issues, as have some on the right. Thank you for coming back on the program. Appreciate it. All right, so what do you make of the DOJ argument here?
Well, I'm glad to be with you. I think it's a particularly interesting argument. You know, the DOJ has gone to great lengths to sort of put out the idea that Trump is like everybody else, and that is that he's not above the law and that the rule of law applies to him. What's interesting here is this argument sort of flies in the face of that position as they attempt to get the 11th Circuit to expedite a case. I mean, you don't have to do much research to find out that expediting a case on appeal is not an everyday occurrence. So I feel like it's a little bit of a hand-wringing with some disappointment from Judge Cannon down there, but at the same time, I'm not sure that they've got the same type of strength of the case they had when they asked for the first consideration. That was to allow them to look at the documents. At least in the initial ruling, the 11th Circuit said you can look at these classified documents. There's an argument that can be made about national security and other things, and there's been no showing of why that shouldn't be reviewed. But here we're really talking about, you know, looking at things like, well, there may have been something commingled, and they use phrases in their pleadings, the government did, like, well, there may be something here, or we may lead to other evidence. That's sort of speculation, and frankly, it's something that's present in every case. So I don't think that there's going to be a great rush at the courthouse at the 11th Circuit to move the case forward expeditiously. It looks to me like it's on track to be briefed at the appropriate time and probably argued. It may mean appeal after appeal. But look at cases all over the country right now where everyday folks have had, you know, their lives put on hold as investigations have taken a long time. So I'm not particularly I don't give their chances a great success prediction.
I guess the argument as to why this would be different is that Judge Cannon's first ruling was viewed as so just appointing the special master at all in this context after the government had already reviewed all the documents, right? So it's not as if the government didn't have access to it. They didn't make their motion in time, so the government had reviewed all the documents. And almost every lawyer that I talked to, former federal prosecutors, et cetera, did not expect a legal ruling that would appoint a special master. She appoints the special master, and now she's nitpicking on what the special master can and can't do, and so that does make it a little different, no?
Well, I don't know that I would say it's nitpicky. And again, I'm no Trump fan, I'll tell you, and I think that the fact that he had the documents is ridiculous. But, you know, that being said, she's telling the special master that he's not the trial judge. And the statute gives her the authority, the rules give her the authority to basically say, look, this is how the thing's going to be operated. You work for me. And so his request that Trump say, you know, and the Trump team makes statements about, well, these documents may have been planted, or these documents, you know, or not. This is not the time or the place for that. The role of the special master is to look for things like, is there attorney-client privilege there? Is it maybe executive privilege? I don't think that's appropriate, but nonetheless, that's what she said. I mean, you can look for executive privilege information. That's what this is. This is almost a record-keeping function. This is not a trial of the merits of the case. And so I was not particularly surprised. I think I said on one of your shows, you know, this is not, it would not be a big deal for her to grant the motion. Because it's designed to sort of be that buffer, the belt and suspenders of the process, to make sure that information that the government should not have access to, in fact, is not in their hands.
I've got 20 seconds left, but you agree that you disagreed with her initial ruling, right, about appointing a special master?
I thought I was not surprised that she would do it. I think I said that it did not surprise me at all that she did it. I thought some of the limitations and the way she did it were different, but at this point,
all right,
I'll try to see the appeal for it.
Michael J. Moore, thank you. Thank you for watching. Go to newsnationnow.com to find NewsNation on your cable provider. And don't forget to click the red subscribe button below to get more of NewsNation's fact-driven, unbiased coverage.